Good afternoon, everyone, and thank you for joining us today for our webinar entitled Creditors and Debtors, Issues Between Landlords and Tenants That Arise During Bankruptcy. My name is Caven Hamilton. I'm currently a 3L USC Gould. I'm an incoming associate at Buckhalter located downtown. And today we're going to be discussing some issues that usually arise during bankruptcy. So given the times that we're heading in towards, considering the fact that we're on the back end of the COVID-19 virus and the shutdowns and all the effects that it had economically, not only in the United States, but across the world, there's been some screams around multiple different industries. Some would say all industries, that people are starting to feel the squeeze. Now you have one set of economists saying one thing and another set of economists saying something completely different. So right now at this point, we don't really know and only time can tell. However, if it is indeed a downturn in the economy that we're heading towards, us here at the Beverly Hills Bar Association have got you covered. Because today we will be covering one of the main issues that arise during bankruptcy, mainly in the leasing and commercial scene in the case of between landlords, tenants, and leasing issues. So with that being said, we have four panelists here today who have all carved out a very big name for themselves in the bankruptcy scene, and those who you can definitely put your trust in terms of informing yourself and getting ready for the impeding times. First, we have the Honorable Sheri Bluebond. Judge Bluebond is a bankruptcy court judge for the Central District of California. Judge Bluebond received her undergraduate and her JD at UCLA, which gives her an extra honorable distinction of being a double Bruin. Go UCLA. We have Monique Jewett-Brewster, shareholder at Hopkins, Carley in their San Jose office. Monique received her undergraduate degree at the University of San Francisco. And of course, she received her JD at USC. Go Trojans.
We're Trojans.
Next, we have Joseph Welch, who is a shareholder of Blank Room in their Orange County office. Joseph received his undergraduate at Brigham Young University and received his JD at Loyola Law School. Last and not least, we have Ivan Gould, who is of counsel of Alan Matkins in their San Francisco office, and he received his undergraduate degree in American University and his JD at UC Hastings College of Law. I would like to say thank you to all the panelists for joining us today. We look forward to a great debate, a great discussion of this upcoming issue, and I would like to pass it off to Joseph since he will be starting off our very first topic here today.
Caven, thank you. Thank you all. I hope everyone can see my screen okay. I'm now going to move into some of the materials, but great to be with you. We're excited to spend some time with you. Thrilled to speak with my other panelists today. I hope it's not much of a debate, but more of an opportunity to share ideas with you as we move into this new economy. So before we get into some of the bankruptcy issues, I think it's really helpful for us to first touch on some pre-bankruptcy considerations. The really good fights in bankruptcy start pre-bankruptcy. So what we have here is due diligence. One of the things you're going to want to look at when you have a landlord-tenant situation is monitoring carefully the tenant's financial performance and potential insolvency issues. I saw reports saying bankruptcies are up 145% this year on last year, with real estate cases in Chapter 11 leading the way. You're going to want to understand cash flow issues with your tenants, problems that may be coming up with your tenants, and get reports. If you say, but Joseph, we don't have good financial reports, something to consider pre-bankruptcy is getting good financial reports, getting good reports so that you understand what's happening with your particular tenant. And part of the reason for that, just to be clear, is to understand, is your tenant likely to need isolated help? Maybe it's going to be a lease modification or something we'll talk about in a moment. Or does this look like we're slipping into full-scale bankruptcy because this is someone who is suffering in all areas? Next area of due diligence is take a quick look at the market lease conditions. You should know what the tenant's abilities will be to reject a lease, which we'll talk about, to assume and assign the lease to a third party. How attractive is the lease? What are the current rents that are required and that you're getting compared to what the market will bear, right? Is it an under market or an over market lease? Third area of due diligence, and this is a big one, review existing lease documents carefully and thoroughly. You want to look at the lease terms. Look for capital D defaults, right? Look for capital R remedies in your documents. Look for cure periods. Look for notice provisions that you need to give. If you're a landlord trying to exercise rights and remedies, you're going to need to know very very carefully what the documents say and what your rights are and what you need to do to trigger some of those rights. Finally, in the due diligence, I've identified consider security deposits, which basically is the landlord holding on to the tenant's money, right? Understand that as we go through our presentation. Also know, how does the amount that the landlord is holding compare to the potential claims the landlord may have? Are you holding more than you may need? Or are you holding less? There's lines of credit to consider as you look through your documents, which are issued by third parties, guarantees and others. So as you look through this, do some due diligence. Next, a lot of that's going to lead you to determining whether there are sufficient defaults under your lease documents to issue a default notice. And if you do, some of the advantages for a default notice early is you start any cure periods. Suppose you've got to give them notice and an opportunity to cure. Well, the longer you wait, the longer the problem may persist. Second point here is avoid and reduce arguments over waiver and equitable defenses like latches or estoppel. Well, you knew you never did anything about this before. Why are you issuing a default notice now? Next one, and this is very important. You may really want to properly terminate a lease before the tenant files for bankruptcy. You'll hear in just a moment that the rights and obligations of the parties as of the moment the bankruptcy is filed is really important as you analyze what people can and cannot do in a bankruptcy. And it may very well be to your benefit to terminate that lease before a bankruptcy is filed. You'll hear more about why that's important. And if allowed by a lease, sending out the default notice may help you in moving down the path to apply security deposits, to draw on letters of credit, or to satisfy unpaid obligations. So I share with you, I think lawyers love war stories and the rest. Here is a provision that I found in a standard commercial lease agreement with the government, where it says, in the event the sublessee with or without sublessor's prior written consent holds over and continues in possession of the sublease premises after the termination date, sublessee's occupancy of the sublease premises shall be considered a month-to-month tenancy, subject to all the terms and conditions of the lease, sublease in effect on the day immediately preceding the termination date, except the monthly base rent for any successive period shall increase to 150% of the monthly base rent. I had this in some of the matters I was handling, where the question becomes, who's trying to terminate the lease? Who's trying to gain possession of the lease? Is it the master landlord? Is it the sublessor? We had to do an analysis to whether they had any reversionary rights, the sublessor. Turned out, even though they labeled this a sublease, it was determined to be an assignment of the full leasehold interest, right? So we start looking at this even closer, and we determine, well, unlike a lot of case law that says that the holdover provision leads into a tenancy at sufferance or a trespasser, this specific provision says it shall be considered a periodic tenancy. So that after the termination date, what happened in this case is the landlord tried to immediately evict the tenant by saying that the lease term had ended, there was nothing to extend, and we're going to file an unlawful detainer action. This case led to a non-lawful detainer action that went to federal court, to the Ninth Circuit. I went twice to the California Supreme Court. And after 22 months of fighting and active litigation, the tenant was allowed to stay there on a valid leasehold interest, right? So you may look at provisions like this. There's been more recently on force majeure provisions where a tenant may be excused from paying rent, or there may be a reduction in rent based on things that are happening. But it's very important to note that under U.S. Supreme Court authority, that whatever rights or interests a tenant brings into a bankruptcy are determined under state law. So it's state law, local law. You've got to look carefully at the provisions to know what are your rights. And the final slide I have for you as we think of pre-bankruptcy considerations is going to be bankruptcy alternatives. Sometimes bankruptcy is not the answer, right? For those of us on this panel, we've suffered through prosperity, right? Many of us have been waiting for the next big wave, or at least I have, right? And so we know that bankruptcy can be a great option. There may be great reasons why a tenant says, I can pass this lease downstream and make some real money, right? In a bankruptcy, it's harder to modify things. If you're going to assume a contract, you take all the benefits with all the burdens. So a lease modification out of bankruptcy before a bankruptcy may be the right answer. It may be something that you want to consider, especially to avoid headaches, right? Avoid payment delays, avoid the risk of getting a new tenant that you don't want. So things to consider. There's deferred rent, extended, reduced terms. I'll say that as landlord, I recognize that many of you have lenders. So you're not at free will to just change whatever terms you want. You want to look carefully at what you're doing from a global perspective. But another big one is additional credit support. Maybe the tenant's suffering through some problems now, and you can add a letter of credit or add guarantees or add something that really, enhances the long-term viability of this lease. And there's also the elimination of tenant options, right? Of first refusals, options to extend. If you don't have the reporting obligations that you really want, maybe a good time to get them, to ask for them. So by way of some big time background, I wanted to set the stage. Often the biggest fights in bankruptcy happen pre-bankruptcy or set up pre-bankruptcy. We're now going to get into a lot of the important considerations in bankruptcy, when you can do things, when you can't do things. And for that, I'm going to pass things over to the Honorable Sheri Bluebond.
All right, thank you, Joe. And I took a quick look through the participant list, and some of you I know could be here teaching this panel. So apologies for the basic level of some of what I'm going to say, because we're trying to bring everybody up to speed before we move into the more nitty-gritty stuff. But anyway, here's some of the basic stuff. So when a bankruptcy is filed, the automatic stay goes into effect immediately, automatically. That's why we call it the automatic stay. And it's going to be in effect even if you don't know that there's been a bankruptcy case filed. And in the Ninth Circuit, based on a case called In re Schwartz, we like to say that actions taken in violation of the stay are void, not voidable. Now, you might be able to come into bankruptcy court and get an order annulling the stay, which would have the effect of validating that action, but don't hold your breath, don't count on it. And also, just to be clear, in the Ninth Circuit, we have a case called In re Grunts, 202 F 3rd 1074, a Ninth Circuit case from 1999. And that stands for the proposition that although the state court has jurisdiction to figure out whether something's barred by the stay or not, they only have jurisdiction to do it right. They can't incorrectly conclude that the stay doesn't apply, because if they could incorrectly conclude that the stay applies, that's the same thing as being able to modify the automatic stay or to terminate the stay. And the only court who's allowed to modify or terminate an automatic stay is the bankruptcy court before whom the case is pending, not the district court, not a different bankruptcy court, got to be that court. So if you really want to know whether something's barred by the automatic stay, the only place you can get that kind of comfort is from the bankruptcy court. All right, and the estate, generally there's exceptions, and pretty much you can assume anything I say, there's going to be exceptions and caveats that we don't have time to tell you about today. But anyway, as a general rule, the estate inherits, it steps into the shoes of the debtor as of the petition date and gets all interests of the debtor in property as of the commencement of the case. And as Joe said, under the Butner case, we look to state law to figure out what those interests are. However, just as we have bankruptcy court's the only place that you can get modification of the stay, bankruptcy court has exclusive jurisdiction to figure out what is and is not property of the estate. So if there hasn't already been adjudicated pre-bankruptcy what the debtor owns, and there's open issues as to whether something is or isn't an asset of the estate, you really need to get that adjudication from the bankruptcy court if you want to be sure that it's going to stand. All right, so that pretty much everything comes into the estate except when there are humans. Humans do have exemptions. Non-humans don't have exemptions. Those are things that you're allowed to keep as a matter of public policy in the hope that you won't be come on the public dole. And that's a whole program in itself. All right, property of the estate does not include property that a debtor holds in trust for somebody else. If you've just got naked legal title but no equitable rights in something, then only it's the naked legal title that comes in, not the actual equitable ownership. So if you have an attorney, for example, who filed bankruptcy, client funds in the client trust account, those do not become assets of the estate. All right, and keep in mind that even if your lease or contract says if the debtor files bankruptcy, they lose everything, or the lease terminates or the contract terminates, don't think you're going to be able to enforce that provision, because we call those ipso facto clauses, and generally those are not enforceable. Again, there's certain exceptions, but as a general rule, you can just forget that that's there. And then the automatic stay prohibits acts to obtain control over property of the estate and actions against the debtor and the estate based on something that occurred pre-bankruptcy. So, for example, Well, actually, let me emphasize actions against the debtor. We look at when the action started. So if the debtor was the plaintiff in the pre-petition lawsuit, that action isn't going to be barred by the stay. If the debtor was the defendant in that lawsuit or a defendant in that lawsuit, it will be barred by the automatic stay, even if by the time we get to the bankruptcy, it's on appeal and maybe the debtor's the appellant and is now the one prosecuting the appeal. Doesn't matter. We look back to, was it an action against the debtor in the first instance? Okay. And then again, subject to certain exemptions, since you can't try to obtain control over property of the estate, you can't do things like record a UCC1 or a deed of trust. I mean, again, there are a few sort of relation back exceptions. You can't write demand letters. You can't declare your default. Even if you declared a default pre-bankruptcy, you can't exercise your remedies. And another thing, you can't stop performing services for the debtor under a contract before, in what we call the limbo period, before assumption or rejection, without getting bankruptcy court approval first. And there's a few scary actions where, you know, the non-debtor party to a contract has been slapped with some significant damages because they stopped performing. Okay, and then it doesn't protect third parties such as guarantors unless the debtor comes in and gets an order under 105, which is a whole program unto itself about what 105 does and doesn't say, but it generally lets us enter orders in furtherance of things that we're otherwise allowed to do under the code, not in direct violation of something we're not supposed to do under the code, but we can do an injunction under 105, but you need an underlying adversary proceeding to do that. Now, I say that it doesn't protect the third parties. There is a co-debtor stay in Chapter 13. I'm assuming we're not going to worry about that. But keep in mind that you might have a step that you need to do in order to trigger your rights as against a letter of credit or as against a guarantor. Maybe you need to serve a notice of default in order to or an insurance company. You may need to do something in order to trigger your rights as against that third party. That is going to be stayed if it's an action against the debtor. But it should not be hard, you know, famous last words, shouldn't be hard to come into bankruptcy court with a motion for relief from stay and say, look, Your Honor, I want to serve a notice of default, but I only want to do it for the sake of proceeding against the guarantor. I'm going to leave the debtor alone. That will still be stayed. Your odds are pretty good of actually getting yourself a relief from stay to be able to go ahead and do that. Okay, so we have the automatic stay prohibits commencement or continuation of enforcement action. So what if you want to bring maybe you've already done your unlawful detainer action and maybe you've already gotten a judgment. Well, can you then enforce that judgment? Or maybe you started the action, but can you continue it? There have been some efforts largely involving residential property in an effort to make it easier for a landlord to be able to actually evict the tenant once they've gotten at least an unlawful detainer judgment or an unlawful detainer judgment and a writ of attachment. Before I get to the stuff on the slide, I want to mention briefly a couple code sections that we got from BHBA in 2005, which is Bankruptcy Code Section 362 B22 and 362L. Effectively, these sections work together. B22 says there's an exception to the automatic stay for the continuation of an eviction or unlawful detainer action by a lessor against a debtor if the lessor got a judgment for possession before the bankruptcy was filed. Again, this is residential property. And that section is not supposed to apply until 30 days after the petition if the debtor filed this certification with the clerk's office and deposited the past due rent with the clerk's office. But I've never seen this certificate. I don't think anybody actually does this, because if the debtors actually had the money to deposit the rent and then pay the rent, they probably would have paid the rent. So I generally don't see much play with these B22 and 362L. Moreover, these code sections are written so badly that I would still recommend, as a landlord, file your motion. It's not hard to file the motion just to make absolutely sure that you're fine. All right, so what if you've already gotten your judgment? In an effort to try to make it possible to actually enforce a judgment, California Civil Code sections, the California legislature passed California Civil Procedure Code section 715.050. And that says if you've got a judgment for possession and a writ of possession, that you can go ahead and kick somebody out anyway, even if a bankruptcy is filed. Well, we have something called the supremacy clause. So California doesn't really get to decide that. So the Lee versus Baca case, that first case was kind of a fun case. The landlord was trying to get the sheriff to evict somebody. And the sheriff is saying, look, I know the code section says this, but bankruptcy law is different. Well, the state court looked at bankruptcy cases and said, bankruptcy law is consistent with this, so it's okay. So they cited In re Smith, which was a case out of our district by Judge Zuzzolo in '89, and then the Ninth Circuit case, Eden Place versus Pearl there. And the Pearl case was actually after a foreclosure, but they still used an unlawful detainer and got a judgment and a writ of possession. So I think it's still analogous here. And bottom line, those cases stand for the proposition that if all you have is naked legal possession, that the automatic stay shouldn't protect you. However, Ivan, let me ask you a quick question. Ivan, you're a commercial landlord. You've got a judgment for possession. You've got a writ of possession. Do you just go ahead and evict the commercial landlord, or do you come in and get relief from stay just to be triple safe?
I don't even think it's being triple safe, Judge. I think I've got to use the Central District handy dandy unlawful detainer relief from stay form, because outside of the residential context, which you summarized very effectively, the commercial is slightly different, because the commercial case law, going back to an old Ninth Circuit case called Waterkist and other cases, say that the commercial tenant retains the right to relief from forfeiture. So under the Civil Code 1179, because of that right to relief from forfeiture, that equitable right is protected by the stay. That holdover occupancy is protected by the stay. And as I'll get into later, then you can have a question in the bankruptcy court, and we've seen it in the Central District in a prominent opinion, as to whether the tenant's entitled to relief from forfeiture or may have contractually waived it. So the short answer is, in a commercial setting, fill out the form.
All right, and I still see a lot of them in the residential setting. So I'm running out of time, but I do want to cover a couple more things real quickly. In rem relief, that is the idea that you can get an order that operates as against the property, so that no matter who files bankruptcy, you'll still have your relief. You don't need to bring a new motion. There was always a bit of a question as to whether we can do that or not. And then we got this code section 362D4, which protects secured creditors. And it says if you can show that the bankruptcy filing was part of a scheme to hinder, delay, or defraud creditors that included either the transfer of all or part interest in the property or multiple bankruptcy filings, that you can get this order that's good for 2 years from entry of the order if you record it with the county recorder or wherever it is that you record your orders. However, a couple of little caveats I want to point out. There is a case called In re Johnson, 346 BR 190, BAP 9th Circuit 2006, which says that now that we have 362 D4, that's the only scenario in which we can grant in rem relief. I don't know, I can't speak for my colleagues, but I've sure seen fact patterns that were sufficiently egregious that I've done it even for a landlord when you've got multiple filings or springing subtenants who start filing multiple bankruptcies. Conveniently, there is some question as to whether or not we really have to follow BAP authority, which is nice because once in a while, I really don't want to. So, it helps. Also, there's some authority for the proposition that if it was a foreclosure, a secured creditor who's already foreclosed and now they're not a secured creditor anymore, they're the owner, that they don't get to use 362 D4. And to me, that seems completely wrong because that's the last step in what you were trying to do as a secured creditor. But anyway, okay, I'm going to skip letters of credit because you're going to talk about that. I'm going to skip set off versus recoupment. The only other issue I want to raise is, that's a big one. When in doubt, ask permission. But let me go to proration for just a minute. Okay, so usually the rent's due maybe on the 1st of the month, might be the 15th. And inconveniently, debtors rarely file on the exact day that the rent is due. So let's say rent's due March 1, debtor files March 8th. Clearly, they don't have to pay for March 1 through March 8th until they assume the lease, or if they assume the lease or assume and assign it. But there is this code section 365D3 that says you have to timely perform all obligations of the debtor arising from and after the order for relief, which in a voluntary case is the petition date. So what about the rest of March? The obligation to pay March rent fell due on March 1, and we call the rest of that month, we call that the stub rent. Do you have to pay it? And what about triple net leases and real property taxes? They're in California or in LA County, your first installment's due November 1, but it's delinquent December 10. Second one due February 1, delinquent April 10. What does your lease say? Do you have to pay it right away? Do you have to pay it when the landlord bills you? And it's attributable to a different time. What do you do? Basically, there's a split in the case law. There's sort of two schools of thought on that. One is You just strictly what the lease says. And if the lease says it's due post-petition, 365D3 says you got to pay it. On the other approach is an accrual approach, and we look to the period that it relates to. And if it's post-petition, then you're going to have to pay it under 365D3. But keep in mind, the fact that you may or may not have to pay it under 365D3 doesn't mean it's not an admin claim. I think I got all the negatives right. In other words, if it relates to the post-petition period, even if the debtor doesn't have to pay it right away under 365D3, it's still going to be an admin claim, an administrative claim that will have to be paid if and when the rest of the Chapter 11 administrative expense claims get paid. However, there might be a consequence to not paying it. The debtor has the money and just isn't doing it to pay the stub rent. You might want to think about bringing a motion to compel the payment of the rent. The debtor doesn't have the money. What's the point of bringing the motion? Debtor can't do it. But if the debtor doesn't at least stay current on the post-petition stuff for after that stub period, there are going to be problems in the case. People are going to move to dismiss or convert. We don't like to have cases that can't run an administratively solvent way, even when you don't have to pay the pre-petition period portion. So any event, bottom line, and I'll say it 12 times in this program, when in doubt, ask permission. It's easy to file a motion for relief from stay. As Ivan said, we have checked the box forms, 21 days notice under our local rules. Some of us even have automatically on our webpage, we have our own little local rules per judge that'll give you an automatic shortening time if you have a judgment for possession in a residential context. And you can always file an application for an order shortening time. And many of us let you self-calendar, pick a date, notice it up for that. So it's easy. I just checked, the filing fee is only $188. So when in doubt, file your motion. So I apologize for running late, and take it away, Monique.
Monique, if you don't mind, before you get started, Judge, if I may hop in. When Judge Bluebond was talking about the accrual method, the proration method versus the so-called billing date, it's important for California practitioners to understand while we do it one way in most of the courts within the Ninth Circuit, and that's proration. In other jurisdictions, most notably Delaware and now the hot Southern District of Texas, where we see a lot of filings, they use the billing date. So you could have one case for your client in Los Angeles that's governed by one method, and you could have another case filed back east for the very same client, maybe a suite in the same office building or another store in the same shopping center, and it's governed by a different rule. So there's a big client education and expectation role with respect to when is my stub rent getting paid.
Right.
Yeah, Ivan, that is a good segue and a good point, simply because we may discuss some of the Ninth Circuit issues here. And I'm seeing Judge Bluebond. That's hopefully because my screen is up, because I don't need to look at myself. But like Ivan said, depending on where the case is pending, you could have an absolutely different result by two different courts and different circuits who are interpreting the statutes we're discussing today in different ways. So definitely something to educate your clients about and to understand yourself when you're practicing in different jurisdictions. So I've got one slide that is short and sweet, and I'm just going to cover the effect of bankruptcy on unexpired leases and executory contracts. And it does kind of take us back, right? Because this is very basic, but we'll lead into the more complex issues later in the program. But Section 365A answers the question of what options are even available to the trustee or the debtor in possession in a bankruptcy case. And that is to either assume and assign or reject executory contracts and unexpired leases. Assumption is essentially meaning that you want to keep this lease or contract and continue to operate and perform under it. Post-petition rejection, essentially like a court-approved breach of the contract or lease. All of this is subject to court approval, the standards for which Ivan will discuss shortly. But there are really interesting underlying disputed contract issues before you even get to assumption and assignment, because the concept of executory contracts, or when a lease is considered unexpired, as Joseph discussed earlier, perhaps a landlord might terminate a lease pre-petition. Is it unexpired then? And even what may constitute a lease these concepts aren't really defined in the bankruptcy code. So how do courts determine whether a contract is even subject to assumption, assignment, or rejection? With respect to executory contracts, and I'll speed it up, there are two main approaches. You've got Countryman's definition, that's Professor Countryman. It's cited in the legislative history for Section 365, and it focuses on the mutuality of commitments under the contract. Essentially, it generally includes contracts on which performance remains due to some extent on both sides, which necessarily excludes contracts that are fully performed on one side or the other. You compare that to the functional approach used by some courts, and that's more results oriented, and it focuses on whether the net benefit to the estate from performance by both sides, the assumption, is greater than the net benefit from the estate's breach of the contract and a payment of any claim arising therefrom. Briefly, Supreme Court decided in a 2019 case, Mission Products Holdings versus Technology, that both of these approaches are still valid. Another dispute that we see arise in bankruptcy cases is whether an instrument that may appear on its face to be a lease is actually a true or bona fide lease or not. Recall, a lease isn't defined in the code. So the question is, how do courts determine whether an instrument designed to look like a lease is a bona fide lease or a disguised other transaction? Courts in the Ninth Circuit examined the economic substance of a transaction to determine whether a true lease exists. It's a really interesting case. I suggest you pull it and read it. It's City of San Francisco Market Corporation versus Welch. In Re Moregio and Sons, Inc. It's 852 F. 2nd 1179 out of the Ninth Circuit in the late 80s. And they examined this issue in the context of a local dispute. The plaintiff Market Corporation had been formed primarily to provide financial assistance to the city of San Francisco to relocate businesses that had been displaced by the city's Golden Gate redevelopment project, which today, for those of us in Northern California, we know that includes the Embarcadero Center, I think the Hyatt, many other structures here in downtown. The Market Corporation was responsible for financing the city's construction and also buying out the owners who had existing possessory rights in the area of the redevelopment project and then relocating those displaced businesses. It did so by issuing bonds and then entering into agreements with the various impacted businesses. So the debtor in that case, Moregio and Sons, was one such business, and it entered into a pre-petition agreement with the Market Corporation that looked like a lease. It granted the business a 50-year use right in certain stalls. It had provisions for basic monthly rent. And after the Chapter 11 debtor was unable to confirm a plan, the case was converted to one under Chapter 7, and the Chapter 7 trustee sought to assume and assign the debtor's lease with the Market Corporation to a proposed buyer. But as the Ninth Circuit decided in that case, even if the instrument, looks like a duck, quacks like a duck, even if the instrument in question might be a lease, if you consider it under California law, it also included several additional terms which the Court of Appeals determined made the instrument not a bona fide lease, but more a joint venture agreement and therefore not subject to assumption and assignment under 365A. So based on the Moregio court, if an instrument has the following terms, it's probably going to be less probable that courts in the Ninth Circuit may consider it a true lease. Like Ivan said, if you're looking at this in a different circuit, do the research because it could be a different result. So in no particular order, the first being whether the rent is structured for reasons other than from consideration to the lessor. Here, the rent was calculated to provide the funds necessary to retire the bonds issued by the Market Corporation. In fact, the tenant's obligation to pay rent ceased upon retirement of the bonded indebtedness. A second factor is whether the tenant assumes obligations that are normally incurred by the landowner. Like the tenant did in Moregio, it bore the responsibility for payment of parking and utility charges, but also Market Corporation's share of any possessory interest taxes that would be assessed against it. There are other factors, just, whether the lessor bought the land for the specific purpose of the lease, whether the lease was structured to reduce taxes. Just know that there are going to be a number of factors that courts are going to consider in whatever circuit to make the determination of whether a lease can actually be assumed and assigned in bankruptcy. So now I'm going to move to timing. Right, because we've talked about some of the interesting contract disputes, but as Judge Bluebond is much more positioned than I can say, but we know that Congress designed the bankruptcy code to pretty much try and be a balance of the competing rights between the debtor, but then also creditors like executory contract counterparties, maybe landlords to an unexpired lease. So there are various timing provisions that are built into the code that have some serious consequences if they are missed. But it depends on the chapter you're in, what kind of lease we're dealing with. So I'll run through these very quickly, and I'll give you the sites, the code sites, so you can check these out on your own time, so I don't take up too much time. But in a Chapter 7 case, the trustee has 60 days after the order for relief or the petition date, the date that the voluntary petition, that the petition is filed, essentially to make a decision to assume or reject executory contracts or unexpired leases of residential real property or personal property. Just know that the trustee can seek additional time before the expiration of that 60-day period for cause. Now contrast that where in chapters 9, 11, 12, and 13, the trustee or the DIP can assume and can move to assume or reject the same types of contracts at any time before confirmation of the plan. Still, as Judge Bluebond was saying earlier, on request of a contract counterparty, the court may order the trustee to make the determination earlier in the case. And just know, maybe the landlord might make that motion in the first 90 days, and the court says, well, I don't want to force the debtor to assume a lease prematurely. So no, it's made without prejudice. So if, for instance, the debtor is unable to perform post-petition, that landlord can come back and say, now look, and possibly get that relief. Assumption and rejection of unexpired leases of non-residential real property have different treatment under the code. A trustee or a debtor in possession has until either 120 days after the date of the order for relief or the date of entry of any order confirming the plan to assume or reject any unexpired lease of non-residential real property. The court can extend that 100-day period for an additional 90 days on motion for cause, but can only grant further subsequent extensions beyond that date with the prior written consent of the lessor. So we have a landlord in, for instance, the Cineworld case, where they have, I think, maybe 800 different theaters. And so they're making the determination theater by theater. They came into the case having made it with respect to maybe 20 or so, but they're still, with the help of their real estate consultant, deciding which leases they want to assume or reject. And I think they've made the motion to extend for that 90 days and then would have to approach each landlord one by one if they wanted to further extend that period. Briefly, the Consolidated Appropriations Act of 2021, or the Appropriations Act, it was the $2 trillion spending and COVID stimulus bill. It made a number of amendments to the bankruptcy code that sunset on December 27th, 2022. One of them here was to extend that 210-day period to assume or reject non-residential leases to 300 days, essentially another 90 days. And that has sunset, except for cases commenced under subchapter 5 of chapter 11 before that date. And that's a whole other program, sub 5, very interesting one. So I'm going to wrap up my portion so that I can get started. But I mentioned earlier that the consequences can be pretty severe for the failure to timely elect or to obtain an extension. So with respect to the chapter 7 trustee, if they fail to timely assume or reject executory contracts or unexpired leases, again, of residential real property or personal property, then that contract is deemed rejected. That's 365 D1. If the chapter 11 trustee or DIP fails, DIP being the debtor in possession, fails to timely assume or reject an unexpired lease of non-residential real property, then the lease is similarly deemed rejected. And the majority of courts, and Judge Bluebond can weigh in as well, but my understanding is that the majority of courts hold that upon a rejection for the failure to timely assume or reject, the landlord is entitled to immediate possession and then doesn't have to go schlep to state court to go pursue its remedies there.
I'd agree. You're supposed to get out.
Yeah,
So how do you compel them, and how do you get the sheriff out there? And you know, we can use the marshal, so we can. It's possible. You could possibly get the marshal to do it. Yeah.
All right. And then for my last section, I'm going to talk about, and really just to follow up on what Judge Bluebond had started discussing, the performance prior to assumption and rejection, that discussion of proration with respect to 365 D3 and what happens to the obligation to pay the partial payment of the month, where the partial month where the debtor filed for bankruptcy, because the debtors aren't so kind as to file on the first or the last day of any month. So under the code's crystal clear under section 365D3 that the trustee shall timely perform all obligations of the debtor under any expired lease of non-residential real property arising from or after the order for relief until the lease is assumed or assigned, with some exceptions that Ivan will discuss. The court may extend for cause the time for performance of any obligation that arises within 60 days from the order for relief, but the time for performance shall not be extended beyond that 60-day period. That's provided by 365D3. I believe the Appropriations Act, I have not had any dealings with this. I would have thought that it came up, but the Appropriations Act, another change it made, it provided sub-5 debtors an additional 60 days to pay rent or perform other lease obligations if it was experiencing or had experienced a material financial hardship due directly or indirectly to the pandemic. I believe that also sunset on December 27th. It does. Okay, except for cases commenced under sub-5 before that date.
Correct.
Okay. I haven't had to deal with that yet, maybe because I'm not sure, but it's very interesting. I'd love to see if there were any factual disputes with respect to whether a material financial hardship arose because of COVID. I represent a number of banks, and very often, our borrowers are in default in 2018, but then they say it was because of COVID. So there are some factual disputes on that. Lastly, under 365D5, right? We've been talking about D3 immediately before, but under 365D5, the Chapter 11 trustee or the debtor in possession shall timely perform all obligations of the debtor arising from or after 60 days after the order for relief under an unexpired lease of commercial personal property. So this is other than personal property used for family and personal household purposes, until the lease is assumed or rejected, again, with certain exceptions, unless the court, after notice in a hearing and based on the equities of the case, orders otherwise with respect to the obligations or timely performance thereof. That's a lot more flexible than section 365D3. But again, if you are not performing the obligations of the debtor, you probably have a lot of issues, not only limited to assumption and assignment of your executory contracts and unexpired leases. And so I will turn it over to Ivan now to discuss assumption and its effects on landlords and tenants.
Thanks, Monique. We start with the proposition that the decision to reject, just like the decision to assume or assume and assign, is governed by the deferential business judgment standard. Once the debtor makes that decision, however, it has the burden of proof on adequate assurance of future performance, which is clearly an element of 365B1. On the issue of cure, 365B1A, it's the landlord has the duty to set forth those matters requiring cure. We usually talk about, is there a default under the lease with respect to cure, but that has been somewhat softened by recent case law. I would commend everyone to look at a relatively new case that's prominent, not just because of its holding, because Weil Gottschall doesn't lose this badly in the Southern District of New York that often. And that case is Old Market Group Holdings Corp., which can be found at 647 BR 104, that case from December. And it says, again, relying on another recent Ninth Circuit opinion, Hawkeye, that a cure does not require a pre-petition notice of default under the lease. A landlord is deemed to perhaps choose not to terminate a lease. It will tolerate a default and not pursue a termination. But when 365 comes into play with assumption and assignment, then that default must be cured. So effectively, a cure statement or a cure response to a motion to assume or a motion to assume and assign substitutes for what would be a pre-petition notice of default. And in looking at that, that's because you've got to look at 365 as a bundle. Unlike many provisions, we heard from Butner early in the program in terms of property rights being governed by state law, 365 bends that a little bit. In essence, 365 takes away the landlord's bargain for consent right. And that's the purpose of 365E and 365F. the idea that the estate is allowed to realize the value of its lease, potentially through assignment. And the landlord's consent right is taken away and replaced with standards under 365. B1, the requirement of cure, the requirement of pecuniary loss compensation, the requirement of adequate assurance of future performance. The judge decides effectively the consent right. But don't stop there. Look at 365K. In this, the debtor gets a release. Effectively, you have a forced novation. The debtor is released from post-petition, post-transfer defaults under the lease. So that changes the terms of the lease and the terms of California law. You should also, tying up some more loose threads, look at 365M. All these standards govern month-to-month tenancies, holdover tenancies. And yes, I've actually had a case where somebody assumed a month-to-month tenancy. So look at 365 as a bundle and look at how they interact. This section is here because something else took something away. And this is part of, as we've used the terminology earlier in the program, part of the balance that 365 seeks to strike. We've also mentioned the fact of ipso facto causes. And I probably have 2 calls a week with clients you would think would be sophisticated, who I have to explain that filing bankruptcy is not a default, notwithstanding what your lease says. And for that, look at 365 E and F. Related to that is triggers based on a default or based on a bankruptcy filing that bankruptcy courts look at as restricting assignment or impairing assignment. So other provisions of a lease, such as an increase in rent or terminating an option or so-called profit sharing provisions. Joe showed us one at the beginning that if you sublease, that you can have a kicker goes to the landlord in terms of consideration. Those are all invalidated by 365 as impairing the debtor's ability to realize value from these provisions. So definitely take a look at how all these components of 365 interact. We also talked about the fact that in a commercial setting versus a residential setting, when does your lease terminate? Is if you've got a pre-petition judgment, you could even have potentially even an issued state court writ of possession. Is the rule different in commercial? And the answer is clearly yes. Because of the availability of relief from forfeiture under state law, which if you take a step back, looks remarkably similar to the standards under 365, curing defaults, maybe paying some attorney's fees, and giving some form of adequate assurance of future performance, although that terminology is not used in the 1179 jurisprudence. The standard's pretty much the same. So a bankruptcy trustee under Ninth Circuit law clearly has, or a DIP, has the power to petition for relief from forfeiture. I would commend everyone to take a look at Judge Kwan's opinion in Art and Architecture Books of the 21st Century, which is at 518 BR 43, a 2014 decision, in which he discusses the intersections of California law on relief from forfeiture and 365, and even there, a contractual waiver of the right to relief from forfeiture, which is found in many modern commercial leases. While we're dealing with the bundle, something probably very few people look at is 365L. I've referred to it as hiding in plain sight. It's a simple concept under 365L that gets lost. Literally, there is one sentence in Collier's devoted to it. There are no known reported cases. There are cases that apply the concept without citation, but 365L simply says if an unexpired lease under which the debtor is the lessee is assigned pursuant to this section, no residential or non-residential distinction, the lessor of the property may require a deposit or other security for the performance of debtor's obligations under the lease, substantially the same as would have been required by the landlord upon the initial leasing to a similar tenant. Now, nobody thinks that this lets the landlord override the judge in the 365 determination, but this makes relevant in a 365 presentation by a landlord what the landlord would do if it was presented with this tenant off the street. As I mentioned, 365 is effectively a compelled novation. The old tenant is being released. The landlord is having a tenant imposed upon it without its consent. It has the right to object. 365L allows the landlord to compare a hypothetical NUCO that walked in off the street and wanted to lease this property. It allows the landlord to put on evidence of what it would require under those circumstances for the court to potentially condition the assumption and assignment of the lease. Why don't we go to the next slide? We talked earlier about the character of rejected leases and contracts. I would urge everyone to look at the 2019 decision in Mission Products. Rejection does not terminate a lease. It is a breach. And that's an important distinction, and I would recommend drilling down on Mission Products. Monique touched on what happens to subtenants, and here we expand to leasehold mortgages. Under state law, the subtenant rises and falls, generally speaking, with its tenant, the tenant and sublessor. So effectively, if a sublease is rejected as between a tenant and the subtenant in this case being the bankrupt party, it operates just like everything else. It's when you get the situation of the sandwich position, the tenant under the master lease and the sublessor is the bankrupt party. That's where things get important. And the prevailing view is that the rejection of the lease would terminate the sublease, but generally debtors will then reject the sublease as well. The evolving view is that a subtenant would not have 365H rights, which again is the subject of an entire program. But again, you want to be careful to understand who's in what shoes when a rejection goes down. As to leasehold mortgages, there is some limited case law, primarily out of the Fifth Circuit, that says a leasehold mortgage would survive rejection. There are no Ninth Circuit cases to that effect, and it would appear that the prevailing view is that a leasehold mortgage would terminate with the lease. I would note that this is why landlords frequently, as part of first day motions in major cases, object to the debtor in possession lender attempting to impose a lien on a lease as part of a all asset lien as part of the credit facility. This is another place where you look at 365 D3. Is it consistent with the obligation to perform, which is not limited to monetary defaults under D3, to effectively breach the lease by encumbering it if the lease prohibits that? We had talked about the duty to surrender possession. As Monique was winding up her comments, I'd point everybody to the Ninth Circuit decision in El Min, which is followed nationally. It is represents the majority view that the landlord is entitled to an order for possession issued by the bankruptcy court. There is no necessity to get stay relief and start your journey through the Superior Court to do an eviction. Under El Min, you can get, and some judges will even issue them on shortened time, a possession order, which you can then have the marshal enforce. And I would just say to anyone who's ever done this procedure, and for those of you who are thinking about this procedure, there's nothing like an eviction done by the marshal service. They are fast, they are efficient, and things are done on a pretty tight time frame. You will not hear from the marshal, oh, we're only posting for evictions on Tuesdays and Thursdays, 2 weeks a month, like you hear from some of the county sheriffs. The marshals do it quick.
What you will hear from them is Your Honor, are we allowed to like break the door down if they don't, they want clarification on just how far they can go to enforce my order. They mean business. Yeah.
And you're right, Judge. The way to get around that, because they do ask that, is refer to some of the California CCP sections as to what a sheriff can do when they do an eviction. And if your proposed order is that a marshal can do what a sheriff can do, they do get that comfort level and they'll do it. And it's pretty spectacular. You don't expect it to go so quickly. A quick word on rejection damages. When a lease is rejected, of course, the landlord has a rejection damages claim that goes along with its pre-petition amounts. And this is governed by 502b6. And of course, this is the famous cap. And the idea of the cap, which believe it or not, dates back to the 1930s, is that in a long-term lease, the landlord won't get a massive claim for lease rejection, future breach of lease, rent loss damages that would subsume the entire estate. The idea is that the landlord eventually can mitigate its damages. It owns the property, so that there should be some reasonable limitation on that. And that is well established and embodied in the code. But there's a couple of mistakes people make all the time with respect to the cap. The most important is that the cap is a cap. It is not the measure of damages. So when you calculate the cap, you actually need two pieces of paper. You need one to calculate your state law damages claim. All in, what's breach of lease, repairs, maintenance, so-called make-ready expenses, your attorney's fees, all that goes on one piece of paper. And then you calculate the cap. And the cap is a formula under the code. It's generally 1 year of future rent and charges, but it's not necessarily if you have a long-term lease. And that's where the 15% comes into play. If your lease is more than 7 years to go, that's just the way the math works, you use the 15% of the remaining term of the lease not to exceed 3 years. So if you have a lengthy lease term, 10 years left to go at time of rejection, you're getting 15 months. You're not getting a year. And that makes up for that longer runway. There are other issues with the cap that relate to how do I calculate that 15%? Is it a question of time? Do I look at the calendar, or is it a question of money? Do I run out the remaining term of the lease? The prevailing view at this point with a lot of bankruptcy court level cases within the Ninth Circuit is Ninth Circuit uses the time approach. So it's actually a function of time. How many months rent is the cap? Another practice tip is you measure the cap, because it's a cap, based on the rent from the petition date, not from the rejection date. Again, it's an overlay. The fact that you got rent during that period, great. That's what 365D3 is for post-petition. The fact that you may start to mitigate your damages, great. The cap is still the cap. It is an artificial construct that you compare to your actual damages. If you mitigate and your actual damages are below the cap, that's your claim, not the cap. The cap is not liquidated damages. It's simply a limitation on the landlord's actual damages. Going back to a theme that Judge Bluebond also touched on earlier with respect to the stay, just like the stay does not apply to a non-debtor guarantor, the cap doesn't apply to a non-debtor guarantor. So if you're ever on the phone with in-house counsel for the parent and they tell you that they're limited just like the debtor is, unless they want to file and open themselves up to bankruptcy court jurisdiction, they don't get the benefit of the cap. Judge, back to you.
Well, we are actually out of time, but let me spend 1 or 2 minutes on Spanish Peaks. We've referred to 365H. That's the provision that when the lessor would reject the lease, that the tenant would have the ability to retain possession, subject to a few little wrinkles and caveats here. Well, what about if you want to sell the underlying property? If you're the landlord who's in bankruptcy, can you sell free and clear of that interest in property, namely the lease? If you can make the right showing under 363F, have a look. If you have that issue coming up, have a look at Spanish Peaks. There's a split in the case law. The majority view is you're supposed to use 365. The way you sell a lease is to assume and assign it. But the minority view says, yes, if you can make it through the showing that you need to make, which in Spanish Peaks was that it was a bona fide dispute, and I'll tell you the facts in a minute, that you can sell free and clear. But a very important caveat in Spanish Peaks is that the way the Ninth Circuit read this was that, don't forget 363E, which says that the tenant can ask for adequate protection if you're going to sell free and clear. And that adequate protection probably doesn't just mean an administrative expense claim, that it means the indubitable equivalent of your interest in the property. So maybe that means that the Ninth Circuit thinks that even if you can sell free and clear, that you ought to be able to get the 365H like rights. And then again, this may be a case of bad facts make bad law, because there couldn't have been a more clear case of a bona fide dispute here. The tenant and the landlord were owned by the same guy who signed the documents on behalf of both entities. One of the leases was a 99-year lease in which it was $1,000 rent per year. Another one was a 60-year lease for $1,285 per year. The tenants never operated on the property. They didn't record the leases. The leases could have been wiped out by foreclosure. I mean, these were sham, ridiculous leases trying to deliver the value of the property to an insider. So one way or the other, the court was going to make sure that that value didn't go to the insider, that it went to the estate. And this may be a situation where Spanish Peaks doesn't really mean you can ignore 365H, but we have to see how it plays out in litigation. So that's all I've got on that. And I think we're out of time. And
actually, we do have a question from the audience.
Okay.
Alan Forsley.
All right. Well, what is the question? I don't.
He actually raised his hand.
Okay. I don't know that we can have him speak. If he didn't type the question, then I don't know how we see the question. Sorry, Alan. Well, here's a different question. Can someone talk about the likely result / analysis where an LL, I guess maybe an LLC, files a motion for relief from, or landlord, no, files a motion for relief from the stay in order to commence, not continue, a UD predicated on non-payment of rent against a residential tenant? Likely result, if it's a residential lease, it's probably not likely to be any value for the estate. That's usually just so the guy has a place to live. I grant those. Why not? If you haven't paid the rent, I'm going to go to grant it. The issue is usually the tenant, the landlord rather, wants me to waive the 14-day stay. I usually don't waive the 14-day stay unless there's been game playing or bad faith. But generally, yeah, there's no reason to not grant relief from stay if they haven't paid the rent under a residential lease. All right. You're welcome. Okay. Yes. Sorry, Alan. You know where to get a hold of me, Alan, if you have a question that you want to ask. Any more questions in the Q&A? Let's see. Nope. All right. Well, I think that about wraps it up. So thank you to all of my fellow panelists and to Caven and the Beverly Hills Bar Association for organizing this. And I think we're done. Yes. All right.
Thank you and good afternoon, everybody.
All right. Thank you.
Thanks, everyone. Take care.
Thanks.